Hello and welcome to another episode of the Modern Divorce Podcast. I'm your host, Billie Tarascio, attorney and owner of Modern Law and Win Without Law School. Today I am joined by attorney Rachel King. Attorney Rachel King practices out of California in Riverside County and really focuses on litigation strategies in the courtroom. Today we are going to be talking about how to develop your litigation strategy if you are a domestic violence victim, which in my opinion can be one of the hardest things to do. So I'm very happy that you're here. Rachel, welcome to the show.
Thank you so much. It's hard. It's hard to represent yourself, but then you throw in an abuse situation and it can be even difficult for the best of attorneys.
It really, really, really can, especially with how the definition of abuse is changing and has changed in the domestic violence field and in the mental health field and hasn't quite changed as quickly, at least in Arizona, in the legal field.
Yes, we are. I'm happy to say that in California, we recently had coercive control and financial abuse become a basis for domestic violence abuse, which
Wow.
can be really good. But you know what? It's still incredibly hard to prove. Coercive
Mhm.
control and financial control
Mhm.
are a lot harder than getting punched in the face.
Oh my gosh, they are. I've even had expert witnesses come in who have written books, who study this, who understand coercive controls certainly better than judges. And judges are just like, I don't think so.
Right. And maybe it's because they get really cynical because they hear the worst of the worst, but it
Right.
exists. And while the laws have changed, and that's always the first place to start, I
Mhm.
think we're still flushing out exactly what that looks like in the courtroom. And
Mhm.
judges are still sort of wary and on the fence about what that means for how they're going to create orders.
Right.
And even though you can appeal family law cases, I mean, people don't. You don't find domestic violence victims that are able to either emotionally or financially appeal a judicial decision. So who knows how long this is going to take.
Right. Right. Okay. So specifically, let's take a hypothetical case. We've got a client and they are the victim of domestic violence and they're going to be representing themselves. Where should they start with developing a strategy?
I think I always like to start with the goal. And I think the goal, especially in domestic violence, is really important because it's fear based and the judge's decisions are based on whether there is a fear. You can, and I've seen judges where there was domestic violence, but there really wasn't any fear. And so the court didn't really think that a restraining order would be necessary or would be helpful. So I think your goal is always the place to start, even in a domestic violence situation. What do you want to get out of it? Are you afraid to leave your house because they're stalking? Is it just incessant phone calls and you need the phone calls to stop? What is the goal? And from there, we can work backwards. And
Hmm.
I think if I had my perfect self represented individual, I would say you start that strategy before you even file the paperwork.
Hmm.
Because the initial paperwork is your opportunity to not just say the current abusive situation, but all of the past, everything that's happened. And most of the time, they're not one off scenarios. The
Right.
time that you finally get into court, it's because it's like the last straw or something has happened where you can't put up with it anymore. So,
Hmm.
understanding that right out the gate and how important preparing your initial filing is, I think is the first way that you can create a really strategic case for yourself and give your uh, make it so that you have the highest opportunity to succeed.
One of the things that I have seen happen again and again and again when I'm representing victims of domestic violence is that their perspective of their life and of their marriage changes as they get space and as they are healing and learning more about domestic violence. So, very often, what they have stated, maybe in their initial petition or in their initial consultation, is very different than what they might want now that they've come to realize the extent of the abuse 6 months in. So, if somebody's in that situation, what should they do?
Well, I think it's really Again, a goal is important. A domestic violence restraining order provides protection. It doesn't ever mean that you couldn't call the police in the future if there was a situation, but it also goes past that. And it goes on if there's children, is it going to affect custody and visitation? Is it going to affect support? Maybe it affects who's living in the house. So many things past the initial restraining order can come into play. And in California, the reason that I say to the extent that you can include everything on your initial filing, the better, is because if you have an abuse, if I get punched in the face today and I go and I file my paperwork and all I put in there is that I got punched in the face today, when I go and I try and litigate that, or I put all of the evidence in front of the judge, I'm going to be confined to only that one instance. But again, typically there's a whole history. So if you can bring up anything from the past, even if it's not specific, even if it's, last year at Christmas, I was told that he was going to kill me if I did something. Your perspective may change, but if you can bring up as many of the past occurrences, then when you're going to tell the judge why a restraining order is necessary, why you are so in fear, and why you are the victim of abuse, you can bring up the entire past. If you don't do that, if you go in and you immediately file, which also might be necessary and might be where you're at, then I think focusing on the history and the shift in perspective and maybe the realization that some things were abuse that you hadn't previously understood can really help in the ongoing legal battle. If you're past the point of getting the initial restraining order. So what does child custody look like? What does property division look like? What does ongoing support look like? You can still bring that up at that point.
How are the protective order cases related to the family court cases in California?
So first we have temporary restraining orders and then we have permanent restraining orders. And when you initially file, you request a temporary and it goes in front of a judge's desk and the judge just reads what you wrote.
I'm
And
sorry,
if they think,
file for divorce or file for a protective order?
file for your restraining order.
Okay.
File for your restraining order. So you go in and you're initially filing for your restraining order. It's on a temporary basis, and the court's going to read what you say, and they're going to decide based on that very limited statement whether a temporary restraining order is going to be granted. Those last for about 21 days. And within 21 days, there's going to be a hearing for a permanent restraining order. And though they're called permanent, they typically only last 3 to 5 years initially.
Wow. Very different than the process in Arizona.
Yeah. And on a temporary, if you get the temporary, very likely if there's custody or children involved, they will grant temporary custody to the protected parent.
Oh, wow.
But that means if you lose your permanent restraining order, you don't get to keep sole custody anymore, right? Because you
Right.
didn't win a restraining order. That being said, I think this is also different than a lot of states. If the permanent is granted, there is an automatic presumption that the abuser should not have any custodial rights whatsoever for their current children or future or other children. So if you win your permanent restraining order, you're going to get sole legal, sole physical custody in almost all of the cases.
Wow. That is very, very, very different than in Arizona. So then your family court case is going to be incredibly impacted by your restraining order case. And if you're a victim of domestic violence, would you suggest before filing for divorce, focusing on what is my case and what is my strategy in terms of a protective order?
I'm not a big fan of using domestic violence restraining orders from a strategy standpoint. I think if you are at a point in your marriage or really any relationship for that matter where you need to seek a domestic violence restraining order, probably divorce is a good idea or separating that out is a good idea. But I think whether or not you file one or the other first doesn't matter. It is true that if you get your domestic violence restraining order on a permanent basis, that court the domestic violence court, and most of the time it's the same court that hears your divorce case, that judge is going to make restraining child custody or visitation orders at that hearing. They may be, again, semi-temporary that need to be flushed out in a permanent divorce judgment. But the fact that there is the domestic violence restraining order is going to cause all of the judges in the family law case to have to handle this presumption that the abuser does not get custody. And that's different than Arizona.
Very, 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 very different. So when you have you don't get a situation often where judges are like, listen, I understand that dad was abusive to mom, but dad's never been abusive to the kids, has a great relationship with the kids. He's going to get 50-50 parenting time. You never see that.
Well, I don't want to say never, because as soon as you say never, it of course exists. So it's a rebuttable presumption. Dad could come into court and say, look, I only abused mom. Judges will consider when they're coming up with some kind of visitation order, whether the abuse was in front of the children or directed to the children.
Mhm.
But the law presumes that if dad does abuse mom or anybody, has a domestic violence restraining order, even with a new girlfriend, that dad loses custody in California, loses legal and physical custody. Dad has the opportunity to come back and to tell the court why that's incorrect. But at that same time, dad will get a visitation schedule.
Okay.
Okay. And visitation will depend very often whether maybe maybe it is an equal timeshare on whether the abuse was directed at the kids or abuse was directed at mom. Were the kids around? How long ago was it? What was it? Was it phone calls? I had one case where mom was granted a permanent restraining order protecting her from dad. Dad made the incessant phone calls, incessant text messages and emails. And we're talking like hundreds an hour for hours at a time, right? But that's all dad did. He never showed up anywhere. He didn't get physical. He didn't really even make threats in the
Mhm.
email.
Yeah.
And so in that case, the court said, yes, we are going to find that this was harassment and it justifies
Right.
a restraining order, and granted it. But then said, we're going to give dad unsupervised, and gave mom sole legal, sole physical custody, but then gave dad an equal timeshare unsupervised, because they weren't concerned that he was going to be abusive to the children.
Wow. So I can imagine under this legal scenario that people are very excited to go get restraining orders.
Yes.
And at least in Arizona, it takes an act of domestic violence that has happened within the last 6 months. And they can look longer, but essentially that's what they're looking at. Um, and many, 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 many people, while their marriage is breaking down, engage in what could be considered an act of domestic violence. Is that the legal standard in California as well? Or what do you have to prove to get this restraining order?
Well, I think it's first important to know that it is often used as a strategy, and that's why I don't like using it as a strategy. I think restraining orders really need to be used because there is an act of domestic violence that caused fear. And I think, because I agree with you that when you are going through any kind of breakup, especially when there's children, people are going to say nasty things. In California, if you throw
Mhm.
something across the room, even if it's not directed
Right.
at a human, that's domestic
Yeah.
violence.
I could take my
Grabbing the
phone and
Trying to grab
smash it
the
on
cell
my
phone,
desk in a fight, and that could be domestic violence, and that could end up where I
ruin
don't
it.
have contact with my kids for 3 to 5 years. That's insane.
Yeah, and then how many times have you heard people that they were recording and then the other spouse went to try to grab the phone? That's domestic violence.
Right.
Blocking a car so they can't leave.
Right.
All of these things. I mean, I'm married. I've been married for 15 years, and I think I've done like almost all of them. I don't think I've thrown anything, but absent that, I've probably said
Like,
all of the things and done it, right?
at our worst moments, most of us have committed what is legally an act of domestic violence. And then you have
Yeah.
real victims.
So we get a lot of dueling restraining orders in
Mm.
California where there was actually an act of domestic violence, right? The two people were fighting. And then they both go because they're getting divorced and they file these competing restraining orders, maybe because there's fear or maybe because they know they're about to get divorced and they're trying to save their custodial rights. I think what I've seen, we have the preponderance of the evidence standard, which is the burden of proof that has to be proven. We've got all of the, evidence of whether it happened, which is also really challenging because oftentimes it's just the two people present. Many times in domestic violence, the police aren't called. So it can be really hard from a he said, she said standpoint. I've had many courts come in and say, I don't know if this was domestic violence or if it's just a toxic relationship, but I'm going to chalk it up to a toxic relationship. And thank goodness you are both, um, getting divorced. I've also had courts come in and grant competing restraining orders, and then they still let the parents each have joint custody. Because what do you do in that situation? They're both abusers. We're not going to put them in the foster system. It doesn't amount to like a dependency situation. So I think there is some, not to get political, but there is some reform that could be done in California to stop the domestic violence restraining orders being used as a strategy and really figuring out how we can protect victims from actual domestic violence, not toxic behavior that results from a pending divorce.
Well, and figuring out what is toxic behavior and what is domestic violence is not something that I understand really. I don't really know where the line is.
And I don't think that judges actually do. I think that's really where they have a lot of discretion and they look at both parties' joint behavior, right? I've had judges say, I watched the demeanor of both parties through this court hearing, and I just think dad is more credible than mom, or I just believe mom a little bit more than dad. That's good and bad, right? That can be
Mhm.
really scary to
Mhm.
have a
Mhm.
judge have so much discretion
Right.
when it affects your long-term custodial rights. But I
Right.
also want to say I've seen judges grant domestic violence restraining orders where the parent abused the children and then immediately grant supervised visitation. So I do think that in California, we're pretty liberal on continuing to facilitate that parent child relationship, even when there's acts of domestic violence.
Okay, so let's talk about that credibility piece because one of the things that comes up over and over and over again is domestic violence victims are often scattered and out of control and they don't present well necessarily. And then the abuser usually presents much,
Controlling.
much better. They're under control. They present better. How do you advise people handle that?
I think even if you're representing yourself, talking to an attorney or talking to a victim's advocate can be really, really crucial to figuring out how you're going to present in case. It's emotional. And when you are the victim, it is totally understandable that you go into court and you cry. But if you can present your evidence the same way that the defending party, the abuser, is going to, which is methodical with here's what happened, here's why I called the police, or here's why I didn't call the police, here's why I didn't prosecute it at that time, here's everything that happened, and try and keep it as fact basis as possible. I think that's going to be the best for a victim. Also, I think pre-planning and putting your evidence together in a chronological order. As an attorney, we do that, right? We figure out the best way to present evidence so that it makes sense for the judge or the jury. I That's often overlooked by people self-representing, but it's I don't even know if it's ever done in domestic violence situations by the victim because it is so much. And
Mhm.
like you said, they forget or
Mhm.
they aren't really focused. They're focused on one thing and not the other. So taking time, and I tell people go back to a calendar, get
Right.
an actual calendar on the internet. back to 2002, however far you need to go, and see how much of your recollection you can jog about different events and put them down there. If you don't know whether it was January 24th or January 25th of 2014, but you know it was around Christmas of 2014, that's great. Get the outline together. And then from there, take notes on what you remember happened. Did you go to the hospital? If you said yes to the hospital, maybe you have to go get the medical records, and take it one piece at a time in chronological order. And then when you go to court, tell your story, and don't get sucked into the controlling abuser's narrative or rabbit hole. Don't defend anything they're saying because they're lying. You don't need to tell the court that they're lying. You don't need to say how horrible they are in court. All you need to do is go back to, on this day and this time, this is what happened to me, right? And if you stick with that, you will have the best opportunity to be successful and to stay out of your own head. And you want to stay out of your own head in court.
Absolutely. So, what should a victim do about all the lies they hear coming out of the abuser's mouth?
Well, we know that abusers are calm, cool, and collected, right? They're usually very controlling individuals, and they present their story as truth.
Mhm.
So, where I think people go wrong is they focus on saying he's lying. And I know that women are abusers too. So I'm
Mhm.
not trying to say, but he's lying. That's not what happened. I didn't say that. I didn't do that. Okay. But you don't need to say anything like that. You just need to stick with your facts and your story, because the judge is going to decide who is more truthful. And if you have your facts clear and presented in the most, I don't want to say unemotional, but the most truthful way, one, it's going to make the controlling person, in my experience, kind of spiral because they're not going to be used to that. But also, they're lying. So there's holes naturally that occur in their story. And I think at that point, you need to trust the judge to be able to see through it. But if you get, out of control, if you can't talk because you're sobbing, if you say I was threatened, I hear a lot of people say, no, but he threatened me, or he hurt me. Those are what I call legal terms of art. And you don't get to say whether it was a threat. You need to say the words. He said he was going to strangle me and kill me. He told me, and say the explicit words. It's okay. The court needs to know the language that was used, but stick to your story. And so I think having an outline and sticking with your outline is going to be the best when you're going up against somebody else. Uh, and if you need to address the fact that they're lying, I think one sentence before you go in and correct it is all you need to do, which is, uh, you know, that is not how I recall everything happened. And then you just go back into your story again.
Sounds great. Okay. So, if somebody is coming to you and they are a victim of domestic violence, and they come to you and they're having a consultation and they say, I'm a victim of domestic violence and it's coercive control, and, we have 3 kids. How do you start there for developing a strategy? They filed nothing.
I go back and I always start with a calendar. Can you go back and come up with as many instances where you think it was coercive control? Sometimes they might end up being legally considered coercive control, or sometimes it might just be, well, he didn't want to eat Taco Bell for dinner or something. Like, that's not necessarily controlling, right? So, but go back and look at a calendar. And the reason I send people to a calendar is because it can get so overwhelming to be inside your own head. And it is oftentimes so much dates and you can't recall anything. But if you sit down and you're like, okay, Christmas again of 2014, here's what I haven't, then it starts refreshing your memory and you can take notes. And so for coercive control and financial control, which are really hard,
Mhm.
I think it's important to go back and write down all of the ways that you think you were being controlled. Did you never have any bank accounts access? Do you have text messages that you had to ask for money? Was there opportunities where you couldn't pay for your kids' extracurricular activities, even though you were, married because you had to get permission. Start writing down all of the ways that you think you were controlled financially or with coercive behavior, manipulating behavior, guilt trip behavior. A really common one that I see is, if you do this, I'm going to leave and take the kids and you're going to be destitute, right? Well, if that happened, what was the pattern of behavior? Was there refreshing your memory and writing even your narrative or bullet points can be really helpful. From there, we can organize it and see, who was there that we might be able to testify. Are there records or documents, text messages that we can go and collect? But we need to have a starting point with as many facts or instances that we have or that we can.
Okay, and can you help define for the listeners what is financial abuse and what is coercive control legally?
Well, I wish it was that easy that we just had like a black letter law on, financial abuse and coercive control. There is no such absolute definition, but the factors, kind of, it's a totality of the factors situation, which are difficult sometimes to understand, looks at if financials were used to gain some kind of control or powerful position in a relationship. So things that I think are really common are not having any access to bank accounts, not having a debit card, having an allowance, but that you have to clear, and not having it be a reasonable allowance, right? If you're getting $20 a week or something and then being asked how you spend, I mean, you can't even go out to a fast food restaurant anymore for that. If you're having to ask for every single thing that money is being used for, or money is being withheld unless you do something,
Mhm.
that is coercive, or that's financial control.
Mhm.
Also, potentially threats of, if you do this, I'm going to leave you, and I'm not going to pay you any support. You're not going to get any of the assets. I'm going to liquidate the 401k and you'll never see it again. Right? That's financial abuse. That is absolutely the only purpose for doing anything like that, or saying it, I suppose, is to try and get some kind of financial, or sorry, some kind of powerful controlling position. And so that's where it's hard to prove, but it's also hard to define. If you feel like you are not able to participate freely and financially,
Mhm.
then you might be the victim of financial control, right?
Okay.
I would also say financial control typically pairs up with something else. It's rare that you only have a financial situation. You might have a verbal abuser with that. You might have some kind of coercive control.
Okay. So let's say the one spouse works and one spouse doesn't. And the spouse that works goes to court and says, I didn't want to be the only one working. I told the other spouse to go get a job. They wouldn't, and then needed me to give them money all the time, and they had terrible spending track record, and I didn't give them the money they wanted. How's that abuse?
I don't think that would be considered abuse, especially if you're pending divorce, right? I see a lot of times where people say, look, he or she needed to get a job and they wouldn't, and I couldn't be
Mhm.
in this kind of relationship. So that was the deal breaker. Like, I'm
Right,
not going to stay married. I
right.
also think it really comes down to, are you trying to gain a position of power? If there's only $2,000 of income and you are having some kind of open communication about financials, hey, we can't afford this. You don't get to go get your nails done every
Mhm.
week. It's not in the budget. I think that's a whole lot different than saying, you have to ask me before you go to the grocery store, and I want to know why you bought a gallon of milk instead of a half gallon of milk, right? I mean, we're really talking about the availability of income and
Mhm.
how it's being controlled. And I think that's different than, you know, the typical money problems that a married couple discuss, which are very common, and it wouldn't be considered financial control.
These are just such hard issues. To me, we're almost tiptoeing in the direction of fault divorce. Even though it's not exactly the same, we're not saying you have to prove XYZ in order to get divorced. Figuring out how to prove if somebody was controlling and their purposes for being controlling is so hard. And then what is the outcome? And the outcome is not having joint decision making and having very limited parenting time, right?
Yeah, and you wanna know another one that
Mm.
really is a kicker? If you are the victim of domestic violence, you do not in California have to pay your abuser spousal support. So can you imagine how this comes up, especially like you were saying in a divorce situation where people are very often participating in one act of domestic violence, and that higher wage earner is like, oh, you just slapped me or you just said something that was domestic violence. I'm going to go file this because when I win, I don't have to pay you spousal support. So the layers that exist to allow domestic violence restraining orders to impact a divorce or as a strategy, I think really undermine the ability of a victim to get a restraining order where they need it.
Right. Because it is, the impacts are so big
Huge. And
that,
kind of I've had people, I don't represent them, but I've talked to people and they've said like, what do I have to lose? So I lose the restraining order. But if I win,
right,
I get the kids or I don't have to pay support.
right.
And at that point, you're really using either the children as pawns or you're doing something that is so catastrophic to and impacts so many people's lives, all for the wrong reason. But maybe
For
that's
a
divorce
long time. Like, your
for a
restraining
long
orders
time.
last a long time.
Not always. I've had judges that have only done them for 6 months, but it still is the same impact. The 6 month restraining order, still you lose custody and you have to then go in and prove to the court why you should get your kids back. And then the most recent change, which was that if I get a domestic violence restraining order on my husband today and he has children from a previous relationship or goes on and has children from a future relationship, that new significant other can use the presumption against him as well. And I'm not saying that victims don't deserve all the protection that they can, but I think it really opens it up for a lot of uh, litigation, abuse of the litigation process.
It's very interesting. And one of the most interesting things to me is just how different our jurisdictions are and how important it is for you to understand what is happening in your jurisdiction, not just legally, but also culturally, and zooming out to really have this very big picture discussion and analysis of what do I want to do now? Because there's big impacts.
Absolutely. And you go to Texas and they're totally different. I mean, every jurisdiction has some crossover,
Mhm.
but I've been involved in cases in Arizona where dad was found to be a domestic violence abuser. A restraining order was granted for, I think it was 4 years. It was a long time, but was still given joint legal, joint physical custody with an equal timeshare,
Right.
and they were separate courts actually.
Yeah.
So it's very different. I think, fundamentally, as an attorney, I really believe no matter what jurisdiction you're in, that a restraining order should be used when there is fear, if and likely to be ongoing, right? You're afraid and the abuse is likely to continue. Outside of that, I think there's plenty of other orders that can be made to handle whatever the situations are, but that's a personal opinion, not necessarily one that the courts would recognize.
That goes back to what you said at the very beginning. It really, these cases should all start with, what is the problem behavior that I need to address? And then what are my tools for addressing that problem behavior? Because it could be that, you have a controlling, angry ex who's not letting you, get the kids therapy. And maybe, yes, maybe you could go get a restraining order for something that had happened when you slammed your phone down or whatever. But maybe there's a different way to make sure that your kids can get therapy if that's the issue. So we just want to be
Absolutely.
really, really mindful of these tools because their impact is just so big.
And when there's kids involved, it impacts the kids not just immediately, but I mean, for years. There's adults that never got over some of the damage that was done by their parents. And I think we get so hung up in our own story and in our own narrative and our own truth that it can be really hard to figure out the best way to proceed through family law. But if you know what your goals are and you can understand the family law philosophies in your area, whether that is as it relates to domestic violence or something else, then it can help you get where you want to be with the least negative impact on you and on your kids.
Yeah, that's great stuff. So attorney Rachel King, she practices in Southern California, Riverside County, Los Angeles, and San Diego County. Is that right?
And then Orange County and San Bernardino County,
Orange
all the
County and
Southern California counties.
all the counties, all the counties. So, and we will make sure to put up your contact information so that people know where to find you. Thanks so much for coming on the show. Any parting words for people?
Remember that if you are the best parent to your children, that you will have the best adult relationship with your children. So as you're going through a horrible family law, domestic violence situation, dealing with a narcissistic, micromanaging parent, if you focus on your relationship with your child, that's going to have the most long-term benefit, because even though family law is all consuming, you're really in it for only a very short time of your children's lives.
Those are wonderful parting words. Thank you so much for coming on the show today, Rachel. I really appreciate it.
Thank you for having me.
Thanks so much for listening to the Modern Divorce Podcast. Remember, anything you've heard today or anything you read online is not the replacement for actual consultation with an attorney and does not create an attorney-client relationship. Even if you called in and we spoke to you, you are anonymous and we don't have your details and you have not become a client of Modern Law. However, we would love to speak with you, or you should seek out the advice of legal counsel or counseling or any other expert near you. And if you have an idea for a show topic or you need to speak with an attorney in Arizona, you can reach me at info@mymodernlaw.com.